A constitutional scholar who served on the Presidential Commission on the Supreme Court, appellate attorney Adam White, joins us now to break down this case. Adam, it's so great to have you back. I love that you come and just give us the skinny on what's really going on. The 303 Creative case is one that confuses many people because it's similar to the Colorado cake baker case. Didn't he win the right not to have to bake a cake for a same-sex wedding? Why is this different?
Well, the baker did prevail in that case and coming out of the same state under the same basic set of laws. But what was really at the heart of that case in the end was the fact that the Colorado Commission in enforcing those laws it created a really bad record in terms that commissioners were clearly biased. At least one of the commissioners was clearly biased against the baker and really intended to punish him for his religious beliefs. In this case, you don't have that same record at all. This is a much broader case about speech as a service. And so in some ways, it is a more complicated case. In other ways, it's a simpler case because it is about speech per se on a website.
And in oral argument this week, the newest justice on the bench, Ketanji Brown Jackson, brought up the issue of race. Let's listen to her comment.
So only white children and families can be customers for that particular product. Everybody else can, I'll give to everybody else, I'll sell them anything they want, just not the It's a Wonderful Life depictions. I'm expressing something, right, for your purposes, that's speech. What about, what's the other step? It's speech, and I can say anti-discrimination laws can't make me sell the It's a Wonderful Life package to non-white individuals.
This wasn't the only time references to race were made. How does the law treat race and issues of sexual identity differently?
Well, in this context, there are a lot of similarities because it arises under the Colorado anti-discrimination laws, which protect against discrimination, both in the context of race and in the context of sexual orientation. Now, I think where Justice Jackson's question was off base was in a couple of ways. First of all, nobody is saying that Ms. Smith is refusing to serve customers based on either race or sexual orientation. She's willing to provide other website services to gay people or same-sex couples, just not websites for same-sex marriages. So it's really not a categorical refusal to serve somebody based on their character or on their nature. It's on the message at issue. The harder question would have been, I think, if Justice Jackson had said that if a company refused to create websites for either interracial marriages or for marriages for people of another race, because one had a fundamental opposition to people of that race or people across races getting married. That would have made it much closer to the context in this case, but nobody is suggesting that's an actual problem in Colorado. I think the case was really dominated by a lot of far-fetched hypotheticals that sometimes made the case actually more opaque and not clearer.
Another comment on the issue of public accommodations or service providers in the American marketplace was made by Justice Thomas. Let's listen to his comment.
The complicating fact here is this is not a hotel, this is not a restaurant, this is not a riverboat or a train. I'm interested in the intersection of public accommodations law and speech.
How did the justices try to balance a website designer's role versus housing or access to water and power?
This was a crucial line of questioning throughout the day. Public accommodations law tends to involve the classic sorts of services that Justice Thomas alludes to there. Hotels, restaurants, famously lunch counters in the civil rights era, where people were refusing in truly awful ways to serve customers at all, to give a meal to a black person in a public setting. You can't do that. The anti-discrimination laws have long prohibited that, and for good reason. But Justice Thomas pressed the litigants, especially Colorado, to give examples of where anti-discrimination laws had been applied and approved by the courts for services that are much more tailored and specifically involving speech. And I didn't hear any answers from the litigants, and I don't think Justice Thomas did either. My guess is that remains a big question for him.
So what do you think will happen in this case?
There's two steps to the case. First, the court has to decide whether it can decide the case at all. There's questions about whether the dispute is really, as we say, ripe as a constitutional matter, since Colorado has not actively enforced this against Ms. Smith and her company. That's not an easy answer. There often are pre-enforcement challenges that are allowed, but it's a very fact-sensitive question, and I'm curious to see how the justices ultimately grapple with it. If they do decide they can hear the basic constitutional issue, I think the justices are lined up to affirm Ms. Smith's free speech rights here, but my guess is whatever they decide is going to be a very fact-sensitive decision, just as the Masterpiece Cake Shop was, and it'll lead the door to future litigation in Colorado and in other states.
So you don't think this will be a sweeping decision?
It's possible, but I think it's going to require a lot of work from the justices and answering a lot of questions that the litigants didn't.
Well, we'll be watching this very carefully, and we hope that you'll come back and join us once they do decide next summer.
Thank you.
Thank you so much, Adam.